evening to every one of y'all. A very warm welcome to the webinar tonight. It's so great at this type of moment, right? To meet all of you here tonight. I'm Len, I'm from MAL. It's my great pleasure to be your MC tonight. Our topic tonight, right, is understanding your legal rights in navigating pandemics. Later we'll explain what that means. Huh? Okay, let me have a very quick chat, right? If you are, hi Joyce. If you are a business owner, can you give me a reply or B? B, yeah? We do a quick survey so that later, right, our speaker can have a bit more time on the area. So if you're a business owner, give me a reply at the comment section at B. And if you're employee, right, give me an E, employee, yeah? And landlord, give me an L. And tenant, give me a T. Okay, good. So far, so good. Hi, Winnie. Good to see you. Okay, the key reason, right, for us to run this webinar with these topics tonight is because, right, we have received a lot of voices from different interest groups about exercising their rights as different role they play. Like, for example, an SME owner say his business had dropped drastically and he asked his manager, right, his departmental manager, to go for unpaid leave. But they refused. And he got stuck because all these managers are so-called the management team in the company. So he got stuck. And he got to continue pay them full time, I mean full salary and then CPF. And he very worried, you see. So he feedback to me, he very worried that he think that this is not going to continue and not going to last him very long. So his concern, I think, is very valid, right, at this junction. And another example is like a landlord nowadays. They have so many landlord feedback that their tenants, right, had defaulted the payment, defaulted the rent for months and months. And then he was concerned also to get a lawyer to help out. But he also heard that at this junction, right, tenants heard to be protected by the law. So, and then thousands of employees, thousands, like you see RWS, right, and many big 100 years of company, right, all retrenching or closing down. So employees are concerned that if they are retrenched, will they be entitled for the employment retrenchment benefits or not? So these are many questions that is pop up during this time, during this pandemics. So what exactly the recent changes of law and how is it impacting our legal rights? Irrespective you are employer, employee, landlord, tenants, creditors or debtors, it is a concern now, right? So the next question that come into our mind is, should I, right, consult a lawyer to understand my legal rights? And which lawyer is good? And then are they very expensive, right? Correct or not? Joyce, you are a lawyer also, right? So tonight, right, we are very blessed, very blessed to be able to invite a legal expert in this area that we mentioned just now, who is willing to provide a public service and give us an update of the changes and the list of questions that we have in mind. This person is none other but Mr. Collin Choo, and very experienced commercial and shipping litigation lawyer with more than 20 years experience in dispute resolution. He specializes in commercial cases such as shareholders dispute, sale of goods, construction claims, contested probate, shipbuilding, landlord and tenant dispute, and many more. He has been involved in all levels of Singapore courts, from the state courts to the Court of Appeal. In arbitration, he has been involved in Singapore International Arbitration Chambers, International Chamber of Commerce, and London Maritime Arbitrator Association. The most important is he believes strongly in helping clients resolve their dispute in shortest and most cost-effective manner. This will mean putting on his lawyer's hat at all times and not be a businessman who wants to prolong a dispute at the expense of the client who has to pay more in legal fees. I think he's a good lawyer, right? Sounds good, right? In short, right? Sorry, the value add that he gives to our clients is that he is always available to explain in simple layman terms. You know, law, there is a lot of language that we laymen do not really understand. And think through as to how best to position the case and how to win the case also ultimately. So tonight, the webinar was planned to be kept in private zone. And actually, at the last minute, with the consent from the speaker, Mr. Collin, he is agreeable to open out to broadcast it to Facebook Live. Yes.
Just now got one. They must die.
Come, somebody, can you off the mic? Thank you. Therefore, please do share the Facebook Live tonight to all your friends and groups so that we can help the community to have less dispute and hopefully more harmony. Okay? So on the other hand, if you have any questions, please type in the zone. There is comment sections there. At the end of the presentation, we have Collin to address them one by one if the time is permit. We aim to end the live section today at 9:30. So please help to mute your mic and then on your video so that Collin can have a better interactions with every one of you tonight. So don't be shy. Collin is here to help us. Okay? Ladies and gentlemen, are you ready? Are you ready? Now let us have our warm welcome to our keynote speaker tonight, Mr. Collin Choo. Collin, please. Collin, please.
Hi, can you see me?
I can see you very clearly, Collin.
Okay,
Good
good.
evening to you.
Good evening, everybody. Okay, thanks, Len, for the very kind words. I think a lot of it not very well deserved, but thank you nonetheless. Okay, being a dispute resolution lawyer, I'm very often the person whom the clients go to only when they got some legal trouble. And I am really not the type of person that the clients want to see because, you know, there's some issue or other lah. So in a way, it is really quite similar to when a person goes and see a doctor. You don't go and see a doctor when you're well lah, unless of course the doctor is your friend. So at the same time, being a dispute resolution lawyer, I have seen how certain issues can escalate from what I think will be the small issues to a full-blown litigation in court. And I think, as everybody knows, going to court is really not something that everybody wants because it is, firstly, it's going to be quite costly, and secondly, it will take a lot of time and effort. And being a dispute resolution lawyer, for me, I think what my advantage is, because I go to court on a day in, day out basis, when I look at the documentation, I can see certain things inside there, certain issues that I look at it and say that, hey, hang on a minute, looking at this thing, I think this will potentially be a problem. So because, you know, this is something which the other party can raise in court against my client. So this is what I think will be the advantage of a litigation lawyer as compared to someone, say, from corporate. But this is not taking away from the work that's done by a corporate lawyer. I can't say that I can do the work that a corporate lawyer can, and I don't think they can also do the work that I can. Okay. So before I start the slideshow, I would just want to say that this is the purpose of today's sharing is just basically that is sharing, and what I say here cannot be treated as legal advice, and you should seek your own independent legal advice if you have any questions. Okay, so what I'll do now is I will share the slides. Okay, I have 4 practical business areas during this pandemic that I want to cover, and I think this will be the 4 basic areas that affects all companies and individuals during this area. Okay, the first area will be that of employment, and for this topic, what I want to do is I want to basically cover the area of what will happen if a company has too many workers and need to retrench some of them, and then what will happen if an employee gets retrenched. The second area is that of contracts. And in particular, I want to look at whether a company, can they say that, look, there is this COVID, I cannot perform. Can a company use COVID as an excuse to get out the contract? The third area is that of landlord and tenant. And this will be basically how are the rights of landlord and tenants affected during this period. This one I think will be the area that will be covering the most. The final area will be that of debt restructuring. Okay, so this will be the area of what are the company's options when he has tried his best to continue with business, but is still drowning under his debts. Okay, the first area is that of employment issues. I have seen some people have said that they are employees. Some have said that they are employers. Please feel free to let me know if you have any specific question. As employers, I think a lot of people as employers, they will be looking at ways to cut costs during this pandemic because you have got a drop in revenue, firstly, or there could be uncertainty about the future. So if manpower cost is a major item in the operating expense, an employer has to see how it can be reduced. And if it's necessary to cut some employees in order to save costs, then I think we could be looking at retrenchment within the definition that's provided by MOM. At the end of the day, the employer can say, well, I'm not retrenching, I'm just perhaps just restructuring my organization. But really, if it falls within the definition that's provided by MOM, it is retrenchment. So we look at what is the definition of retrenchment. This is defined as dismissal on the ground of redundancy or by reason of any reorganization of the employer's profession, business, trade, or work. So you can see here, it can be redundancy or reorganization. So this will be the definition. Next, I move to this area of what are the steps to be taken before an employer considers retrenchment. Firstly, you all must consider that there's a tripartite advisory on managing excess manpower and responsible retrenchment by MOM, NTUC, and Singapore National Employers Federation. So what does this advisory say? It says this: it strongly encourages employers to take a long-term view of their manpower needs, including the need to maintain a strong Singaporean core. Now, this is always very sensitive nowadays to have a strong Singaporean core. Next, the advisory says this: when managing excess manpower, retrenchment should always be the last resort after other options have been considered and found to be unworkable. Okay, so bear that in mind, they should be the last resort. So we look at what are the alternatives that companies should consider other than retrenchment. First, you can have retraining employees. Second, redeployment of employees to other areas of work. You can have flexible work schedules or arrangements such as shorter work week, hours, or you can even put a person on a temporary layoff. You can ask the employee to have no pay leave or even pay cut. Okay. Please note if you have at least 10 employees, you will need to notify MOM within 1 week of any cost-saving measures that would affect employees' salaries. So for example, you have a pay cut and you have got 10 employees. You will have to notify MOM of this pay cut within a week. Okay. So after the employer has tried all the alternatives, found that it still cannot work, revenue is still very low, you have no choice but to retrench. So the questions that the employer would have to consider first will be this thing, and this is nowadays is actually very well, I wouldn't say very fashionable, but this is something which the tripartite partners want employers to do. It is called responsible retrenchment. Okay, responsible retrenchment should be done in 3 ways. The first way is not to discriminate against employee or groups of employees. Second, you must communicate clearly the reason for the retrenchment. such as, for example, the business is bad. What is the criteria that's used for the retrenchment? For example, oh, you are very new in the organization. We want to retain the older ones. And third, the employer should also help the retrenched employee look for new jobs. The third criteria for responsible retrenchment is that the employer should pay all salaries, including unused annual leave, computed up to the last day of work. Okay. So this part here, I think is quite straightforward. Next, I come to the question. Is it necessary for an employer to notify MOM of retrenchment? The answer is quite straightforward. Yes. If an employer has at least 10 employees and retrenches 5 or more employees within any 6 months period, you have to notify MOM. The notification process is actually very simple. All you need to do is just go to the MOM website, and then you can actually find the page where you can notify MOM of the retrenchment exercise. So I give you an example. Say a company has 15 employees as at 1st of March 2020, and the company retrenches up to 4 employees as at 1st August 2020. So you've got March, April, May, June, July, August, 6 months. In this case, you do not need to notify MOM because only 4 employees were retrenched over this period. But what you will have to notify MOM when you retrench the 5th or more employee during this period. Okay. The reason for the notification is not for MOM to punish the employer. So you don't need to worry and you try to say, no, I don't want to notify because I may have something, I may have a black mark against me. No, that's not the case. After you have decided to retrench and you have already carried out the responsible retrenchment, you have to consider 2 more things. The first is what is the notice period to be given to the employee who is going to be retrenched? And the second, is any retrenchment benefit payable to the employee? Okay, let's deal with the first issue first. Notice period. For the notice period, you have to follow the employment contract. If the employment contract says 1 month, you have to give the 1 month. 2 months, the same thing, you must give the 2 months notice period. If the employment contract is silent on notice period, then you have to follow the Employment Act. Okay, the Employment Act is quite straightforward. If the employee has served less than 26 weeks, so this is about 6 months, the notice period is 1 day, quite short. And if the employee has served between 26 weeks and less than 2 years, notice period is 1 week. And the last one, if the length of the employment is between 2 years to less than 5 years, then the notice period is 2 weeks. Okay, so you have to give the notice period according to the employment contract or according to the law. Responsible retrenchment also means that the employer should give a longer notice period. Look, at the end of the day, when the employee is retrenched, there's going to be a period of time in which he or she is going to be out of work. So it will take time for the person to look for work. So this is why employers are encouraged to give a longer notice period, and then also to help the employee to look for new job. You can either through your own friends, or you can go to Workforce Singapore or the Employment and Employability Institute. This thing called E2I. Next, I move to this question of retrenchment benefit. Is retrenchment benefit required under the law? The answer is no. So this is good news for employers, not so good news for employees. Okay, but of course, when it comes to retrenchment, when it comes to responsible retrenchment, the tripartite partners has recommended that for an employee who has served at least 2 years to receive 2 weeks to 1 month's salary for every year of service. So this is the recommendation. Those with less than 2 years of service could be granted an goodwill ex gratia payment. So what this means is that although an employee is not entitled to payment, the employer is still giving it. Okay? If your company is unionized, then you have to see the collective agreement. I understand that the norm is 1 month's salary for each year of service. So it's always much better to have a union as far as the employee is concerned. Okay. So if there's any payment dispute between an employer and employee, you can always refer and resolve it at the Tripartite Alliance Dispute Management. Does anyone have any questions at this point in time? Okay.
I have a question, Colin.
Yes.
Pertaining to retrenchment benefit, right? Actually, I received many questions. That's why I thought to have you to actually address to all my clients and then
Okay.
all the group.
Okay.
Pertaining to this retrenchment benefit, right? Because retrenchment, it can be take it as very close to redundancy also, right?
It will be that.
Retrenchment means that the job is actually still used to be required, but it's now no longer required. Is because of the change of the crisis or the current climate.
Correct.
So the job is no longer required at this point of time. So retrenchment, although you say that it's recommended, so it's not compulsory. What about those people, those staff, right? They probably work in the company for more than 10 years, and it come to the point that it is still required, but the company can take this opportunity to actually remove this senior staff in such a way that so that the company can save more cost as to hire a junior staff. I mean, less your experienced staff. Can that be done?
Okay. The answer to that is unfortunately yes for the employee, because retrenchment benefit is not mandated by law.
Okay. So it's
So this
more
is not a
on
requirement.
like recommended. So it's up to the employer whether they want to pay retrenchment benefit. But is that period of time or during the situation they have to pay retrenchment benefit?
Sorry, I can't. Oh, I think you're frozen already.
Okay, my question is retrenchment benefit by right is part of the so-called under the MON rules as a recommended. So
Correct.
if they say not because of crisis, right? Not because it makes the law.
Sorry, you got frozen again.
I got frozen. My network
Yeah.
is a bit weak. Sorry. My
No
question
problem.
is retrenchment benefits under the law, right? Actually, is mandatory or not mandatory, irrespective whether is it under the pandemic situation.
Okay. The short answer to that, it is not mandatory under the law.
Even it's not under pandemic.
Correct. Singapore does not have a mandatory retrenchment benefit requirement.
So, dear employee, you take note of that. The retrenchment benefit is not mandatory under the law. So it's up to the employer.
Unless there's a unionized company, then there will be a collective agreement between the union and the company.
So these have to be pre-arranged, or it can be arranged on the time that when the company actually retrench the staff.
Oh no, if the company is under a union, then there will be a collective agreement. So the company will have to act according to what's inside the agreement.
I see. Okay. Okay, I got it.
Okay.
So if they don't agree, then they have to go to the Tripartite Alliance Dispute Management or get.
I have also understand from some clients who have gone there. Clients will be ex-employers. They will basically get quite strong arm twisted to paying retrenchment benefit.
Sorry. What do you mean on that?
For those who go to the Tripartite Alliance Dispute Management, they will get the employers will be strongly encouraged to pay retrenchment benefit. So I think there'll be a lot of psychoing lah.
Yes. Of course, it depends on the negotiation power already.
Correct.
Of course, if the company have unionized, right, then the negotiation power probably is stronger lah. Then they got bargaining power.
I'm referring to those non-unionized company and the employee complain to the Tripartite Alliance Dispute Management. So like you say, someone who has worked in a company for 10 years and then gets retrenched. So the person can go and complain to this Tripartite Alliance Dispute Management, this TADM. So when something like that happens, the company and the employee will be caught up, and then there will be some, they will discuss with them, and then the company will be strongly encouraged to pay something.
Okay, but it's strongly encouraged, not mandatory, right? So it's still up to the employer whether they want to pay or not.
It will
Correct?
still be, ultimately it will still be that. Of course, you got someone who's very tricky, don't want to pay me, don't want to pay. But you,
yeah, lor, because they can, it is, especially in this time of pandemics, right? It's so difficult already. So
correct.
the employer might have financial difficulties to come up with a retrenchment benefit also. And then, of course, as a government, you cannot force the company to close down also by paying the retrenchment benefit. Yeah. Okay,
yes,
sure.
you're right, you can't.
Explanation. I shall not delay you further.
No problems. Anyone have any more questions on this?
Before Colin move on, if you have any question, you can type it at the comment sections. We try to pick it out. If not, right, we will answer it at the end of the sections. Okay?
Okay. Then next I move on to contract. Okay. The basic rule in Singapore is this: freedom of contract. So this means you can have contract, you can negotiate contract for anything you want. Okay, you can agree to any contract terms subject to, of course, certain restrictions provided by the law. So now we are here today, we have got a pandemic. Some contracting parties will definitely not be able to perform, and they will default. So when there is default, and especially if there's a lot of default, we are going to have a lot of problems. So this is why the government have responded very strongly to this issue, and this Mr. K. Shanmugam, Senior Counsel, said this on 7 April 2020 in an interview with CNBC. He said this: "You are looking at economic devastation, businesses destroyed, people lives ruined, and in such a situation, you don't talk contract. You talk equity, you talk justice, you talk about what's the right thing to do." And I find this actually a very resounding and some statement, which to me, I feel very strongly for, because as a lawyer, we always go by the book, by the contract. The contract says A, you follow A. You don't try to do something else B. But when it comes to today, can you still tell the other party, say, no, I want you to perform, I don't care? So the answer has to be that there has to be a certain give and take, especially when it comes to today. Okay. So in the usual case of a breach or default of contract, the innocent party can terminate the contract if the breach is actually very serious, and it's so serious as to go to the root of the contract. Or if the breach is not so serious, then some time should be given to the wrongdoer to rectify the breach or default. Okay. We now have a situation of this pandemic, the government has stepped in. The government has come out with 2 acts of parliament. This will be the 2 laws that I'll be talking about. The purpose in these 2 laws is to give some breathing space to the parties, so that they do not need to immediately perform their obligations. So here this do not need to immediately perform their obligations. It doesn't mean that they do not need to perform. So it just gives them some breathing space. Okay. So these 2 acts are these: the COVID-19 Temporary Measures Act 2020. It offers temporary relief to businesses and individuals who are unable to perform their contractual obligations due on or after 1st February 2020 because of COVID-19. Okay, there will be certain types of contracts that will be covered by this act, not everything. So these contract obligations will cover those obligations performed on or after 1st February 2020, and it is for those contracts that were entered into before 25th March 2020. So it means if you enter into contract on 1st April, well, sorry, it's too bad. The act doesn't cover you. The second act will be an amendment to this first act. So now this act name is called COVID-19 Temporary Measures Amendment Act 2020. So for this amendments in the act actually provides a rental relief framework for SMEs, and it also enhances the relief that's available to businesses, organizations, and individuals who are unable to perform their contractual obligations because of COVID-19. And then what it also does is it introduces a cap on late payment interest or charges for specific contracts, and it provides relief for certain parties affected by breaches or delays in construction or supply contracts where the breach or delay is due to COVID-19. Okay. So, like I said earlier, only certain types of contracts are covered by this Act. There are 7 contracts that are covered by this Act. If your contract does not fall within this list of 7 contracts, well, you will not be entitled to the relief that's given in this Act. The 7 contracts are these: leases and licenses of non-residential properties. The second is offer to purchase and sale and purchase agreements with housing developers. So this will be like an individual buyer of a house. The second will be hire purchase and conditional sale agreement. Fourth, lease or rental agreements for commercial equipment. For example, you can say a machinery. You have a lease agreement and now you don't need it because or now you cannot perform because of COVID. So this will be covered. The fifth will be secured loan agreements to SMEs. 6, event and tourism related contracts. I think everybody will agree that event and tourism related industry are very badly hit because of COVID. 7, construction contracts and supply contracts. Again, we all know how many dorm workers are affected. The workers have not even really fully started going on site for construction contracts yet. So definitely the construction and supply contracts will be affected unless the relief is granted to them under the Act. Okay. Out of these 7 contracts, I will be dealing with lease later on in my sharing session. What I will want to do is I will deal with those contracts that do not fall within any of the 7 categories. So the contracting party will not be entitled to the relief in this Act. So what can we do when it comes to a contract like this? I give you one example. You contract to buy apparel for sale, and then because of the slowdown, you no longer want to go ahead to pay for the apparel. Can you then say that, no, I don't need to perform because of COVID? Another example, someone cannot ship goods to the buyer because of the lockdown or shipping restriction. Can the person say, no, I cannot perform, or I don't want to perform anymore? How can we rely on COVID as a reason to discharge your obligations under the contract? Okay. There are 2 ways in which the contract can be discharged. The first way would be this. There is actually a force majeure clause inside the contract that allows you for it. Or the second will be this thing called discharge by frustration. When it comes to a force majeure clause, some contracts there will be a force majeure clause, and the clause will actually provide for the contract to be discharged upon the occurrence of the force majeure event. So usually when it comes to yes,
when it comes to the technicality of the words, right? Can you explain first before you continue? Like for example, the force majeure clause, right? I think most of us don't understand.
Okay, no problem. If you see the
turn.
slide, okay, if you see the slide at the bottom of the slide,
Yes.
I would have already given an example of such a clause.
Yes.
Can you all see it?
Yes.
Okay, so this type of clause is usually quite standard. I given one example here. All it says is this: neither party will be liable for any failure or delay in performing an obligation under this agreement that is due to the following clauses to the extent beyond its reasonable control. Then the words following down will be the force majeure events. Example, acts of God. What would be acts of God? For example, flooding, or you have got fire, for example. Things like this, something that is totally that is not human cause. Okay, so we call this. Then you have got accident, riots, war, terrorism act, epidemic. For this particular one, there's this thing called pandemic. Okay, so the rest of it you can see. So you can see that from this clause itself, right? It actually has all the examples of the force majeure events actually listed inside there. Okay. 2 points
So
to note now.
The COVID-19, right? The COVID-19 at this point of time, right, is considered a force majeure cause also, right? Force majeure,
Okay.
I say, because it's act of, is it considered act of God?
Okay, for this, luckily, for this particular clause itself, the word pandemic is there. COVID-19 has been declared by WHO to be a pandemic. So we are quite covered there. We can say that this COVID is a force majeure event because it is a pandemic. But what happens if it's not inside there? Not so straightforward, COVID-19. If it's not inside the contract, it is not inside the contract. So you cannot say that, yeah, it is. Is it really an act of God? I really cannot say for certain, for something like this, because I don't think we have come across an event that is so world-changing as this COVID-19. It is possible, but I don't think we have come across that. All that I can think of is the Spanish flu in the 1910s. That one didn't affect Singapore, so I'm not sure how the courts will actually look at COVID-19 and actually say that this is an act of God if the only thing inside the force majeure clause is act of God. So not so straightforward.
So this clause, I think, is more on business owner, right, who actually enter into contracts with counterparty. Let's say they involved in the contracts and there is the non-performer or contract from either their side or their counterparty, right? They might actually call out this clause, which might apply to them, right? Either party for them themselves, especially maybe like Mary construction performance of the contract, right, might be interrupted by this pandemics.
Correct.
Yeah.
You are right there.
And the events also, they say events supposed to call out in certain times and it's not able to call out.
Correct. You are right there.
So they actually cannot fault as the party, I mean the event organizer, which cannot actually perform because of the government's rulings as well as the safety of the people also.
You are right there. So we have to see whether for the COVID, you have to see whether does it actually appear inside the contract. If yes, then you have to see whether is it really fall within the force majeure clause. And then what is the effect of the clause? Okay, so in this example of a force majeure clause, it says here very clearly, neither party will be liable for any failure or delay. So if this happens, the contract is discharged. But certain contracts, there is the contract is not discharged. What will be given is an extension of time. So for example, you're supposed to do something by 1st of July, but because of the COVID, you cannot do. So then the extension of time will be granted until such time that you can actually perform the contract. Okay, so you have to see what is the wording in this clause. I have given the example on this slide of this term here, PSSCOC. This refers to the public sector, the public sector conditions of contract. Okay, where I'll show you the clause itself. Sorry, let me just. Never mind. Okay, sorry, something is wrong with. Okay. Sorry, doesn't matter. I want to show another. Okay, let me. Can you all see this? This is called the Public Sector Standard Conditions of Contract for Construction Works 2014. I have extracted two clauses. The first clause is 14.2. You can see it's very wordy. this basically says if all these events are at this page, you see A to H. If any of this thing has happened, there will be an extension of time. Okay, so I look at clause 14.2. The only thing that's relevant for the pandemic will be force majeure. You have got everything here. None of these clauses inside here applies to the COVID-19. You can see it's very lengthy, but it doesn't actually apply to COVID-19. Even when you look at clause 25.2, which is referred to at clause D, can you see D? 25.2 talks about accepted risk. You look at accepted risk, it doesn't apply to COVID. So the question, if this PSS COC actually applies, the question will be whether the pandemic is it actually a force majeure event. I think the answer will be most likely yes for this, but like I said, everything is still very new. We don't really know how the courts will rule on something like this. Okay.
Yeah,
precisely.
Precisely. Yeah, because COVID-19 have not happened before.
Correct. I'll move on to my
so
next.
It might not be in the clause also.
Correct. I'll move on to the next topic, which is that of
Yes.
frustration, and I will raise one example where it finally where the frustration event was finally decided or confirmed as a frustration event about 7 years later by the courts. So you can see it actually takes quite a long time. Okay. Okay, so when it comes to frustration, even if there's no contract clauses that allows the party to be discharged from its obligation, it is possible that the contract will be discharged by frustration. Okay, so frustration means that there must be a unforeseen event. So in our case, we will say is COVID-19 that's beyond the control of the parties. Of course, it must be beyond the control of the parties. Has occurred such that the contract is treated as frustrated or discharged. So the effect of this frustration is similar to that of a force majeure clause, and the contract can be discharged. Okay, but you must note frustration is an exception. Okay, and then it must go towards the very nature of the contractual rights and obligations of the parties, such that it becomes impossible. Hear the word, becomes impossible or commercially impractical for a party to perform its obligation. Okay? So if you have a case whereby COVID-19 just makes it more expensive for one party to fulfill its obligations, like for example, seller from China wants to ship goods from China to Singapore, but then you cannot do it directly because the shipping line doesn't go from China to Singapore anymore. The seller must consider whether or not there are any other ways. For example, you ship to Hong Kong, Hong Kong to Malaysia, and then Malaysia to Singapore. So if it's possible to still perform the contract, even though it's more expensive, the party would still have to do so. Okay. Then we come to this case. What happens if a seller of perishable goods and then the seller cannot perform because of shipping restrictions? What does that mean? Does it mean that the seller can say, okay, sorry, I don't want to sell to you? Or does it mean that the seller would then have to look for other sources of goods so that it can actually ship to Singapore? Something like this, unfortunately, there's no straightforward answer. It is very much dependent on the facts. Okay, so we have to look at a few factors. We have to look at perhaps looking at whether, in the case of the shipping, whether shipping is really impossible, or is it just there's going to be a delay? Whether is it possible to get the goods from point A to point B? We also have to look at factors such as what is the source of the goods. Like for example, if something is going to come from a country in which nothing will come out from there, then most likely it will be frustration. The fourth factor that we can also look at is what is the cost of sourcing for the alternative goods. Because if you cannot get it from China, can you get it from another country like Hong Kong, Taiwan? If yes, then the seller will have to do so. the point to note, there are not many cases where frustration of contract has been successful. I talked earlier about a previous case that took a long time to actually complete, will be the sand ban. Okay, the Indonesia in 2007 actually banned the export of sand, and the ban came very suddenly. So one day, Singapore's major source of sand supply is from Indonesia. One day it was Indonesia, and the next day Indonesia said no. So the ban actually created a lot of upheaval in the construction industry, and suppliers and contractors claim against each other. So it was not until 2014, 7 years later, that the Singapore Court of Appeal, the highest court in Singapore, finally found that the sand ban actually amounted to an event of frustration, such that the contracts were discharged. Okay, there are some points inside this case that will be relevant if someone is to say that COVID-19 is a frustration event. Okay, in this case, it was found the fact that the price of alternative supply of sand is higher, it does not mean that this will become a frustration event. So I say it's higher because the Singapore government actually released the sand from its released some sand from its own sources, and the supply and the prices were higher. So, when a supplier says, look, I previously contracted with you, for example, $10 for 1 ton, but now I'm getting my sand for $15. I can't sell to you at this price. So the court has found the fact that the price in itself is higher does not amount to a frustration event. But if the price is actually very, very high, so for example, from $10 to $50, is like for 1 ton, and then you're selling, like, for example, 1,000 tons. So of course, if the amount is very much higher, then yes, it is possible to become a frustration event. So what the party will need to show is that its obligation has become radically or fundamentally different from the one agreed to. Okay, so I have to emphasize again, this COVID-19 is very new. We don't really know how it's going to pan out. But to me, my own gut feeling, it is very different from what happened in 2007, because in 2007, Indonesia banned the supply of sand. In this case of the pandemic, I think we'll be looking really at a delay for most contracts. I don't really see a case where we say that the contract cannot be performed.
Yeah, and the words, right, you say cannot be more expensive, or more difficult to perform, right? And just now you also define that more expensive as in like how many times or more expensive. It's very subjective, right? Because like especially big contract, right? They probably have forecast that this contract, the margin is already very low, and then they say because of the COVID-19 and they're lacking of the materials, they're lacking of the manpower, they're lacking because of the turnaround time is longer, because of the logistic obstructions in between. So then the whole contract, the project itself might actually end out, right? It's supposed to have margin gain, but it become a loss. So such, is it considered more expensive? Because let's say, for example, I'm the one that running the project. I know that this project, if I were to pursue, right, it's going to bring me a loss. Is it called
Sounds very unfair, right?
Or not expensive?
Sounds very unfair, right?
Yeah. It's like you know already, and you still chunk for the losses. Then it's like not make sense, or. But
does.
of course, to the contracted party, contracted terms is contracted terms. You have to fulfill the terms. You have to fulfill the terms. So, I think this is quite argumental, lah.
Oh yes, definitely. So that is why the court actually used this test, radically or fundamentally different. So you say that, if the margin is very tight, like you say, and then you continue, you make a loss. Is it really radically or fundamentally different? I mean, you can say nobody enters in a contract to lose money, but hey, this is just too bad, right? That's the other way of looking at it, lah.
Yeah.
So, but if it actually amounts to a big loss, So for example, you can say that, you know, instead of making a little bit of money, but then you're going to end up with big losses, then yes, if it's very clear like that, then I think you can say that it's fundamentally different. Okay.
Yeah. Yes. And I think the points that I take here is, if you are a business owner and you are going to enter a big contract, right? These are the terms, since COVID-19 has happened and it might happen something else in future. So these are the terms like for example, just now we say force majeure terms, COVID-19 terms, the pandemics, these type of terms should be in the contract, right? Especially big contracts.
Oh yes, yes.
These are the terms that must consider already in future, because previously we might not think that such thing will happen, you see. So if you are project, I think enter into a contract, I think these are the terms that need to come up lah.
It will be the standard terms inside there, but the other question will be whether or not the standard terms will actually cover the pandemic.
Yeah.
So nobody really knows yet. I mean, at the end of last year, who would have thought that we will be where we are today, right?
Correct.
Okay.
Correct. Yep.
Anyone has any questions?
They have questions about other things. Maybe
okay, no problem.
Topics later we can pick up instead of stop you from between, right? Maybe we okay, there's one related to this question. Sylvia asked, right? He said, moving forward, is it better to add pandemics into the future contract? She is also under construction.
Okay. You know, construction, there will be a lot of standard terms.
Then actually illustrate, right? Can pandemics be recognized in normal contracts and unforeseen circumstances? How about when there is time, the world found a vaccine for COVID-19?
Okay, that's a good question. The main thing is we are looking at today. So if, for example, you say that you cannot perform today, you'll be looking at today, not say middle of next year if the vaccine is found middle of next year. So if today you cannot perform because of COVID, then the contract should be discharged today. It doesn't matter that that the vaccine can be found, say, end of the year or only next year or 2 years. So it doesn't matter. And when you use the term pandemic, this has to be a term that's actually that is declared, by the government authorities. So in the case of COVID, it's actually by WHO.
Okay. So it's not any terms that we can.
Oh no, you cannot. Yeah, you cannot just use pandemic.
Okay, so the terms have to be WHO approved terms.
Correct. Pandemic was something declared by WHO.
Okay, sure. Thanks for your explanation.
Okay. Then I move to the next topic, which is that of landlord and tenancy, and we will be examining how are the rights of a landlord and tenant affected during this period. Okay. As I said earlier, landlord and tenancy, as well as license agreements of non-residential property, is one of the specified contracts that are covered by the 2 Acts. Okay, so 2 things: non-residential property. If yours is a residential property, just too bad, you are not covered by the Act. And the second thing is, you can, whether is it a tenancy or is it a license, you are also covered. So as we all know, the government doesn't interfere in the contract. But in this case, it decided to do so because of the potential scale of the economic impact of COVID-19 on SMEs. So not individuals, on SMEs. So what the government has done is they want to take targeted and temporary measures. Temporary means it's only for this period, to intervene in the contract to safeguard the economic structure for the common good. So we are not looking at a person or a company. We're looking at a common good, the good for all, for everyone. So we have the rental relief measures in the 2 Acts, which are necessary to support the SMEs and the broader economy. So like this, what they also want to do is they want to help the property owners to continue to enjoy the stable value of the assets in the longer term. because if a tenant cannot perform and the tenant gets out, it just gets out of the property, can the landlord find another person? During this time, I think it could be difficult. So this is why I say that the relief is temporary and it's for the common good. So everybody bears the pain. Okay, so there are 4 main points in these 2 acts relating to landlord and tenancy. The first, you can see from the slide, there's temporary relief for up to 6 months that's granted to SME tenants who are unable to pay rent. The second, rental relief or waiver for SME tenants. And the third is statutory repayment. Rules on holding over, I don't propose to deal with it. If you have a question, like for example, you ask me, what is the difference between a lease and a license? The very simple and short explanation is that a license does not give to the licensee exclusive possession of the premises. Exclusive possession means when you enter into a lease agreement, you pay your rent, you comply with all your obligations, the place is yours. You lock up, the landlord cannot just go into your place because this is your place. You have exclusive possession of the place during the term of your lease. But when it comes to licenses, you don't have exclusive possession. Okay, but whether is it a lease or a license, both are covered under the Act. Okay? So I deal with this thing called temporary relief for 6 months, and this period is up to 19th of October. That's granted to SME tenants who are unable to pay rent. Okay. So what this means is that when it comes to a tenant who's not paying rent, what is the usual case? Tenant doesn't pay rent, the landlord will re-enter, kick the tenant out, and then sue for outstanding rent. I think all this is quite standard. We do quite a fair bit of such cases, so all this thing is really run-of-the-mill type of cases. But what happens if the tenant is unable to pay rent due to COVID because his revenue has dropped very drastically? For example, F&B and those in hospitality business. I mean, we all know the circuit breaker 2 months. Now we're now in phase 2. Has it really improved the situation? A bit hard to say lah. So when it comes, so what will happen if the tenant is facing threats of eviction because the tenant has not paid rent? What the tenant must do, must serve a notice for relief on the landlord. The tenant must take this step of serving this notification for relief. The template, you can actually find that at the MAL website. It's actually very comprehensive, but this must be the trigger. You serve the notification for relief. There's no such thing as an automatic relief. Once the tenant serves this notification for relief, the landlord cannot do certain things against the tenant up to 19th of October 2020. It cannot do 4 things. First, terminate the lease or license because of non-payment of rent. Landlord also cannot re-enter the premises. Landlord cannot start or continue with any legal action for non-payment of rent, or even apply to wind up the tenant because of non-payment. The landlord also cannot on its own impose new charges, like for example, oh, you don't pay me rent, you need to pay me extra sum of money, or you have to pay me interest 10% or 20% per annum. All these things the landlord cannot do. Okay? So you must know, you serve the notification for relief, it stops the landlord from actually doing any of this thing for up to 19th of October 2020. It doesn't mean that the tenant doesn't need to pay. It just stops you. The obligation is just there, but it just put on hold up to 19th of October. It doesn't mean that you don't need to pay anymore. It just gives the tenant breathing space so that you can try to discuss with the landlord, some mutually acceptable solution for the payment of rent. Like for example, instead of paying $2,000 rent a month, can you then pay 1,000? And then you pay installments, something like this.
Okay, about this, to this point, right? Can I ask to this point, right? Because this one is causing actually a lot of landlord unhappiness because they claim that they have loan to serve, bank loan to serve. They have the renter as a sole income to them. They need to survive. How can the tenant don't pay? And then they also have many questions like they have their obligation to fulfill also. How can the tenant not paying? And then if 6 months they're not paying already, then at the end of the day, they will do default and not paying. So there are many of this sort of scenario that happen.
Okay, you are absolutely right.
One particular one is they want to use a security deposit.
Okay, you can do so. If let's say you have 3 months security deposit, you can makan 2 months, you can keep 1 month. So this is allowed under the law.
So it's you say there is 2/3 of it. 3 months you can keep for 2 months. Keep 2 months as a renter to pay rental, and then 1 month to security deposit.
Yes.
Also that allowed under the law.
Yes, that's allowed under the law. Then only after the period is over, after the 6 months period is over, then you tell the tenant, please top up. Top up the SD lah. So this is just temporary relief. The idea is, of course, after 19th October, everything is okay lah.
Okay, provided it might okay or not okay, like it might end up in the situation as in there's a lot ugly situation come back.
Yeah, either that or we may have a new budget, then you may have more relief measures. I don't think that is out of question also. Okay, but the idea is, yes, if the landlord is absolutely right to feel angry because the landlord is saying, hey, I got mortgage to pay, you know.
Yes.
So there's also relief that can be granted to the landlord for the landlord to seek a temporary stop in his mortgage payment. Stop, that doesn't mean it don't need to pay at all. So it's also a breathing space for the landlord.
But ultimately still have to pay lah. So
ultimately still have to pay lah. Same with the tenant one. Tenant is just given a short period, a short holding period not to pay.
The difference here to us as a contractual owner, right? They say, for example, contractual owner, right? You see the bank loan is secured loan, but the tenant is unsecured loan, right? So there is difference in between. You cannot default secured loan, but the tenant can default the unsecured loan.
The main thing with that, if there is any threat by a bank or financial institution to try to go against the security, the property, the owner can also say that, can also apply for relief. So this is one of the acts one of the contracts that's covered by the acts.
Okay, so second one, right, the rental relief, right? Just now you said point number 2, rental relief to SME tenants. The situation here is for they said 4 months for commercial and retail, right? 2 months for office industry. So now in the market, there are so many questions, that noises in the market that the landlord have said that they have not received the government funding, and they do not want to release the funds to the tenants. And then tenants was also struggling because they are emphasizing that government come up with this relief, the budget, right? It's basically helping them to tie to this most difficult time. And then how can they hold back, you see? So both sides are not wrong.
Okay, for that, it's actually rental waiver. So you don't need to pay for this period under the law. So I understand the cash grant, the notice of cash grant by IRAS to the landlord will only be issued sometime in mid-August, maybe from beginning to mid-August. So nobody, I don't think anyone has gotten the cash grant yet.
Yes. So the landlord has making such statement that they cannot give the cash grants to the tenants, and then tenant must continue to pay. Otherwise, they will exercise whatever. But but of course under the law they can't exercise much, but they have the frustration now. So what is the law what is that, the clause about this cash grant? So the landlord still have to give, is it? Or they put it in this way, they cannot enforce to collect lah.
Yes. So
Is it?
if you have, so for example, you are a tenant. If you're a tenant, you are under the, let's just say you qualify lah, you are an eligible tenant. The landlord cannot then say, please pay me, because under the law you don't need to pay. But at the same time, the law actually says that the statutory waiver, this means the waiver under the law, doesn't kick in until the landlord has received the notice of cash grant. So you have a chicken and egg thing. What can a tenant do? My advice is always very simple. If the tenant is facing threats from a landlord to say you pay, I don't care because I have not received from IRAS the cash grant yet, so you must pay. And that you don't pay, I'm going to kick you out. If you have a landlord like that, then you just apply for relief. Because once you apply for relief, the landlord cannot kick you out or cannot sue you because it's against the law.
Okay.
So they are right. They are right in the sense, they also feel very, very angry.
Yeah,
because
correct.
they have not gotten it yet.
Yes. They also angry because they also don't receive and they cannot collect their rental.
Correct. Yeah, you are right.
But somehow it's no choice, right?
For the common good, this is the word. Sounds very communistic, for the common good. But
Copy.
it's what it is.
So landlord
it is what it is.
In this chat group.
Okay, if the landlord is really suffering very badly, right? The landlord can actually apply to a relief assessor and say, look, I cannot afford to give 2 months, because like for example, if the landlord is an old retiree who depends on the rental income, what's the person going to do? Cannot afford to survive. So the landlord can actually apply to the assessor to see whether the relief can be cut by half. So instead of 2 months relief that is granted to the tenant, the assessor may say, okay, then I only give you 1 month. So both sides, the landlord feels the pain because they have to give 1 month, but the tenant also gets a relief by half.
Yeah, I read about that also.
Yeah.
If the landlord can prove that they are also financially trapped, right? Then they actually apply for half of the relief given. But they still have to give. It's just that it can cut down into half.
Correct.
Okay. Any questions about this? Let me see. I received some questions. Should I wait until the end or?
Oh, you can ask now if you think the question is relevant here.
Okay, there's one question for Marco. He said tenancy agreement signed on 9th of March should be kicking when renovation period. Tenant can't start operation. Tenant need to pay rental. His is industrial property. Okay, I repeat.
19 March.
Agreement 9th of March. It's in
9th
the
of
chat
March.
also. 9th of March.
Okay.
That means before April
Yeah.
So circuit breaker actually kick in April during his renovation period. So his question is, tenant could not start operations. Tenant need to pay rent or not?
Okay. The short answer to that is the period for the rental relief is before 25th March 2020. So if you tell me 9th of March, then yes, the tenant will be entitled to the relief.
Okay. So Marco, right? Marco here. Marco, you still the contractual. I think here is about, is he required to fulfill the contractual obligation? Is he still need to pay rental? So my understanding, correct me, Colin. he still have to fulfill the contractual obligation as in contractual obligation, he need to pay rent, but he will be entitled for the rental relief, right? So it's two separate things, right?
Correct.
Yeah. So Marco, if the question is being answered, if not, then you can type your questions again, okay? So we go to the next one. It's also about tenancy. What about residential? Janice asked, what about residential property?
Okay. If the residential property, whether is it used for business or for homestay, too bad, doesn't apply.
Yeah.
No rental relief for
does not
residential.
apply.
So,
Correct.
like for example, you have a Soho. Maybe even a Soho will not apply. Shop house, yes. Shop house, if the part of the shop house is for business, the upstairs is used for residential, then the downstairs one will apply, not upstairs.
Okay, for this release, right, as far as I understand also, it's mainly for businesses. Why government actually come into picture, not because of the residential, is because they want to support retail. They want to support commercial, industrial. They want to support businesses to make sure that businesses be able to survive through this most difficult time. So why the government step in to actually pump in millions of dollars on this matter and then come to interfere? So why is it residential was not covered is because of that. Because residential, whether is it during COVID or non-COVID, right? The impact, not say totally not affected, but impact is not as bad as retail. Because retail is us, COVID, CD, the circuit breaker is a must, is a mandatory requirement for all the shops to close. So they have big impact on that. Correct, right?
Yes,
Correct me,
you're absolutely right. So even for you must know, it's not for everybody. If it's not for very big company, because they are the qualifying criteria. So one of the criteria is that the SME must not have more than $100 million in annual revenue in the financial year ending 2018. That is based on the year of assessment 2019. So if your company is very big, then of course you may not be entitled to the relief because you can survive. But if this is designed to protect the smaller boys.
Yeah. Correct.
If you enter in the contract, like let's say for example, you enter in the contract on 1st of May, I mean by which time you should already know that the COVID situation is quite bad. You've got circuit breaker, you enter into it with your eyes open. It's a risk that you take. So that's why there's no relief granted for such people.
Yes. Okay, another question here about this is hot topic now. The relief period, Tom, right? Tom, relief period is from March to June or from June to August. As tenant says, no need to pay for 6 months.
Wow,
Tom,
so good.
Tom, your tenant quite fierce. That's why Colin, this is really a lot of gray area and a lot of interpretation. Although the courses, the law ministry, right, they actually publish about the measure and the reliefs, but many people interpret differently also. That is why there is so many disputes and there's so many, debate and arguments, which is why you come into the picture,
I think the main thing, because this whole thing came suddenly, nobody expected this, and then you have got the first time ever the government coming in and telling people, oh, you can't do certain things, you can do certain things. So there's a lot of uncertainty. So when I hear something like, oh, I don't need to pay rent for 6 months, no such things lah. If anything, you are only you don't need to pay, but after that you must still pay. Your 6 months don't just disappear like that unless it falls within the rental relief framework. So outside of that, you have to pay.
Okay, so the question here is tenants say no need to pay, meaning they have to pay, but they can delay. It's called deferment of payment, and no need to pay is different. Yeah, they can defer payment. That means their rental is actually cumulative for 6 months. And there's also one more cost is landlord, you can charge interest. If your
Correct.
contract, the tenancy agreement itself, say that when there is a late payment, there is an interest imposed, you can impose. Of course, there is a guideline for that, like how much you can impose. You cannot impose as sectionary also. You can impose based on the tenancy agreement. Basically, go back to the tenancy agreement. It's just that they need to pay, it's just that they defer the payment. Right, Colin?
Yes, you are right. So when it comes
I read about this also.
When you talk about this deferment, right? There's this thing here. You see the third line here. It's called statutory repayment scheme. What it provides for is basically under the law installment payment. Okay, so if today you think you cannot pay, you just go and serve a notice on the landlord to say that you want to pay according to the statutory repayment scheme. So there are a few points to note for it. When the tenant does it, the landlord cannot say I will reject. And the other thing, the tenant must be eligible SME who qualifies for the additional rental relief. So if your company has an annual revenue of $110 million, too bad, you're actually too big already. And the tenant must also, the revenue must drop more than 35% from last year and this year. Okay, so then you can apply for this installment payment. The installment payment will be, you can accumulate up to 5 months rent for commercial properties and up to 4 months rent for industrial office properties. So you will say that, landlord, I want to pay by installment. I want to pay, if let's say you got a shop, I want to pay 5 months of rent over the next 6 months, also can. Then your first installment will have to start by 1st of November 2020. You cannot say I only want to pay 1st December or 1st January. Cannot. You have to pay by 1st November 2020. Again, like I said, this is because they think that everything should more or less have settled down by November.
Okay, this is another slide, right? Defer payment, installment payment scheme. Right?
It's called a statutory repayment scheme. So it's basically just a fancy name for installment payment. But
and they have to settle the cumulative of 6 months rental arrears in 5 months, right?
No, you have to settle for different type of property. You got different amounts. So for commercial property, this means shops, 5 months, total is 5 months. You can accumulate up to 5 months. You must pay over, I think is 9 months. Then for industrial office properties, it is 4 months, I think it's the same period as well. And then the landlord can charge interest, capped at 3%. 3%
per year or per month?
Per annum.
Per annum, okay.
Per year.
So meaning they say the tenants were to actually unpaid, didn't pay for 6 months. So they start the first installment in 1st of November. That means the 1st of November month's rental also had to pay, right? Plus the cumulative of 6 months they not paid.
Correct.
So it can be a cash track also.
Can be very strong also, you're right.
Yeah, can be quite.
But of course, if you keep 5 months, right, you got the rental relief for a shop for 4 months. So effectively it's only 1 month.
That is for commercial. That is for retail lah. That's for retail and commercial.
For retail lah. Yeah.
So there is
it's not so bad lah. Not so bad lah. Because office property is 4 months. You get.
No, office 2 months. Office 2 months.
Sorry, 4 months total arrears, and then you can get 2 months of rental relief total.
Yeah.
So in a sense, it's only 2 months. So not so bad lah. So that's why I say it doesn't kill away a person. It doesn't get rid of a person's obligation to pay. It is only a temporary measure, temporary relief. We hope that by November, things will be better.
Okay, Marco, right? Marco here, he asked, relief means defer payment. He asked, the definition of relief, is it defer payment? But relief here is rental waiver, right?
Yes, rental waiver. There are 2 parts to it. first is the rental waiver under the first law, then the additional rental waiver under the amendment law.
Okay, Marco. And Janice here asks, right, if the tenant TA signed by the company for their employee fail to pay rental, can the landlord chase them out?
Sorry, what do you mean?
Okay.
Tenant,
If the tenant TA signed, that means a company signed a tenancy agreement for their employee. This is residential, I think.
cannot.
Can the landlord chase them out?
Cannot, because it doesn't apply at all, because the property doesn't even fall within the act.
Yeah, Jenny, this is not commercial. This is for the staff to stay, right? Then definitely it's residential already.
Yeah.
Irrespective whether the tenancy signed under company or tenant, the nature of the property type itself doesn't qualify for it. Okay. There's someone that on the video. Can you please off it? Thank you. Okay, next question, right? May I ask, how can we terminate the lease during this period? Assume there is 2 to 3 years left. Oh, this may probably is the tenant or a landlord. He asked whether can terminate the lease at this period or not. If there is a 2-3 years left.
I think you have to see what is the reason for termination. If the reason is, for example, you're telling me cannot pay rent, then the short answer is you can't, because if the tenant serves the notification for relief, you're stopped. But there's a big but. If there's some other breaches by the tenant, then of course you can then of course the landlord can terminate if there are other breaches for other things.
The questions here probably is, if can you clarify, okay? In fact, we are in the zone, you can actually speak out also. If not, right, my understanding from her questions here is, can she actually terminate the tenancy agreement that left about 2 to 3 years due to this COVID, due to this pandemic? Can't, right?
You cannot.
Yeah, the contractual obligation is still there. Okay? And Sun Wee, Mr. Wong Sun Wee, is it Mr. Wong Sun? He said, I rent out my shop February 20, but no contract signed yet. So can claim rental relief. Okay, this is another question. No contract signed. No contract signed.
You're supposed to pay stamp duty and everything lah. I think go and get it done. Go and pay the backdated stamp duty.
So Mr. Wong probably is the landlord lah, I guess.
Yeah.
He said, can my tenant claim SME rental relief?
I think the tenant can.
But no contract signed.
Yeah, but then the person is there, right? Since February, right? You cannot pretend that the person is not there.
The contract actually signed, the so-called verbal agreement is February 20 lah, but no contract lah.
Yeah, but the person is there lah. So you're supposed to get everything done lah. You're supposed to get everything signed. It's more difficult, but it doesn't mean it's not.
Yeah, you need to get the paper documentation done out lah.
That would be the best.
Yeah. So no gray area on this. Okay. So far still got a lot, but I think we address them later. We proceed first. What about that?
Okay. So we have covered quite a fair bit of things. The one question which will be something like this. I'm not sure how whether it has even happened. Let's just say a very kind-hearted landlord, let's say in February, decided to give certain relief to the tenant. Certain relief, let's say you give a 1 month waiver, and then after that, can the tenant then say, oh, you still need to give me my relief under the law? The short answer to that is no, because the relief that was given by the landlord can fall within the total package under the law. So if let's say the total package under the law is 4 months, the landlord, being a very kind landlord, gave 1 month or 2 months before that, then that will fall within the total package. But if the landlord decides, for example, to say, I reduce your rent for the rest of the term, then this is something which they agreed to.
So you're looking at totality lah.
Yeah.
Okay.
Okay. Then you can also ask the question, like just now we talk about the installment payment. What happens if a tenant pay let's say 1 month, 2 months, and suddenly decides doesn't pay? What can the landlord do? The short answer to that is the landlord can then demand for immediate payment of all the outstanding arrears, and then he can even say, I terminate, I want you to get out. So this is because there's a breach of the installment payment scheme. Okay. There's also a possibility where, let's say, for example, the tenant applies for relief. The landlord is not very happy with it because the landlord thinks that, wow, this tenant actually just very 操惯, just doesn't want to pay. If the landlord thinks he can try to get the tenant to pay, the landlord can actually apply for the assessor determination. So under the law, there's this group of people who are appointed as assessor. They will determine whether the tenant is entitled to relief. So for example, whether a tenant is entitled to the additional relief. If the landlord is also not happy with the decision, is also not happy with the tenant's application for additional rental relief, the landlord can also apply to the assessor to confirm whether the tenant actually qualifies for the additional rental relief. Okay. Any more? Do you have any other specific questions regarding this? If not, I will.
Okay, should I pose the questions here?
Yes.
Okay. There is this, Okay, what happened, right? Okay, this one I think you answered. Never received the cash grant from IRAS. Then
Not yet,
can the landlord demand for the tenant to pay, right? This one I think you answered. Then the other question is, can the landlord actually take actions against the eligible tenant for non-payment of rent? Cannot, right?
Well, technically you can, because it's not until the cash grant, but the tenant can easily apply to file the notification for relief. So that will jam up the landlord also.
Oh, so the landlord actually can take legal action. Can take legal action.
Of course can.
But the tenant can exercise the, what is that called?
Submit the notification for relief.
Oh, submit the notification to relief.
For
so
relief.
that then the landlord will have to stop the legal actions.
Yeah, correct.
Okay, then I think landlord, I don't know who is a landlord. Maybe no point at this time.
Well, the complaint I have heard is that this is very one-sided towards the tenant. That is the common complaint I've heard.
Yes,
the tenant supposed to getting so much, and then like what you say the landlord must pay the monthly mortgage, but then you got no choice, got to continue to pay, but then you have got rental relief. It's really not fair. But this is under the law.
But there are tenants that I'm not meant to pinpoint any tenants. There are really tenants that is really take the opportunity one,
Of course they are. Of course they are.
Yeah, they will take such opportunity to probably default or then don't pay for 6 months. Then after that, right, close it or something, close it out and then open another one. There are such things happen.
Definitely they are. Yeah, definitely they are.
But then you can only take legal actions against them, right? Ultimately.
Yep.
You cannot stop their tenancy agreement. So basically, landlord very poor thing.
The
Very poor thing
landlord
have to rent the place
cannot
for
do
6 months. Then after that, they cabut already.
after 19th October, there's always a risk that the tenant can run away.
Yeah.
There is.
Oh, cannot make it. Or they can claim that they cannot make it.
Of course they can. Of course they can. And
Okay.
and the danger is that by which time if let's say for example you only have 1 month of SD, then the 1 month SD is not going to be enough.
Confirm not enough.
Yeah.
Okay, next one, right? It's also about this, because this one a lot of dispute. They ask, right, can the tenant do if a landlord takes action such as re-entry or sue them? Or sues?
So just file the notification for
What can
relief.
a tenant do? Or what can a tenant do if a landlord takes action such as re-entry or sue them?
The same thing.
Same thing, right?
The same thing. Yeah, you file the notification for relief if the tenant is an eligible tenant and then the property is one of the qualifying properties.
Okay. So they still have to apply now. They have to apply now.
They
Once
still
they
have to
apply already, they are protected.
Yes. This one, the
So
information on
landlord, somehow tenant are protected now. So you
yes,
take legal actions, they probably drag for more than 6 months.
correct.
Okay. Okay, this one is what happen if a tenant does keep to statutory repayment, does not, is it? Repayment
Does not,
scheme or tenant terminates the tenancy. What happen
Straightforward.
if
Straightforward. If it's a tenant who actually breach by terminating or by like suddenly not being at the premises anymore, then you can take back, the landlord can take back the property and then sue for the entire outstanding.
So if they don't follow, that means they not keep to the statutory repayment scheme, right? Then
Correct.
landlord can exercise the full rights like before COVID.
Correct.
Okay. So if landlord dissatisfied with the tenant's notification of relief, then they have to file something. Do they need to?
Sorry?
How
Yeah,
do they
you
actually protest?
You will have to go and get it assessed. You have to send for it to be assessed by an assessor.
Same thing, right? This one same thing as if the individual who depends on the rental income also, and this is also another way of protest that they do not agree to the notification for relief served by the tenant. Then they have to get the assessor to assess the situations.
Correct.
Okay. You are more or less covered all the questions that the audience asked.
Okay. Then I move on. So this slide, this is what we talk about. You cannot terminate, you cannot start or continue any legal action for non-payment of rent. You cannot also re-enter or forfeit. Okay, so just now this is what we talk about. You can claim for outstanding rental if the tenant doesn't pay, or the tenant terminates, or even if let's say the landlord can terminate the lease for another default for something else that's non-payment. Okay. So now I move to the next and final topic of debt restructuring. So what are companies' options when it has tried its best but it is still drowning under its debts? Colin,
sorry.
Yeah.
Before you come, because this is the debt restructuring is another topic, right?
Yes.
Yeah, I missed out two other questions that I thought we just addressed to them. There's one for Tom, right? He asked, right, if the tenant don't pay and also demand for tax rebate, they can even make money from the rent.
I don't really understand that.
Tom questions. Okay, Tom come from the perspective is he said his tenant don't pay already. Then ask for because there is a property tax rebate here. Remember, there's besides the rental relief, there is property tax rebate. That means before the announcement of the rental relief I think in May budget, right?
Yeah.
Government actually announced the property tax rebate. So they
Correct.
actually require, they actually give the property tax rebate to the landlord and ask the landlord actually pass down to the tenant.
Okay.
So Tom, the question here is, his tenant don't pay, but actually demand for the tax rebate. And then they make money from the rest. Can like that, man?
Okay. This one, if the landlord, so my earlier example of a very kind-hearted landlord giving way or giving relief, his own relief to the tenant before the budget, right? I think this will fall within one of the reliefs. So if I've already given the relief, right, then the tenant cannot be entitled to like rental waiver plus the tax rebate. This will be like, wow.
Okay.
Very
So
benefiting.
here, the point here is the property tax rebate, right, is part of the rental relief, or is on top of the rental relief, or the whether 2 months or 4 months?
Okay, previously the government talked about that. So now everything has been clarified, because previously they say that, oh, you need to give the property tax and things like this. But now it's very clear the tenant doesn't need to pay. He gets the rental waiver.
So sorry, you get rental waiver. So property tax is part of the rental waiver. So whether 2 months or 4 months, right, is actually inclusive of the property tax rebate or
Yes.
exclusive?
It's different now because property tax rebate goes to the property owner.
Yes.
So it goes to the property because that is supposed to cover the non-payment of rent, the waiver, the rental waiver. So the tenant cannot get the property tax rebate. All the tenant gets is waiver of rent. It doesn't need to pay 2 months or 1 month.
Okay.
If it qualifies for the additional relief, then you got another additional 2 months or 1 month, depending on the type of property.
Then last one, right, about these topics also. Janice asked, right, how to apply for rental relief? No need to apply, right? How to apply for rental relief? I think she
Don't
is
need
the
to apply.
tenant. Janice, your tenant,
thing.
right? Huh?
It's automatic.
Automatic have to be given by the landlord one, right?
Has to be given by the landlord, you're right. The landlord, the landlord cannot say that I want you to pay.
So Janice, you can talk to your landlord.
Of course, if the tenant has already paid, the tenant can get it back either by refund or saying, then the next month rent I don't pay you. Also can.
Okay. Good. I think all questions clarified.
Okay.
Thanks, Colin. We can move on.
Okay. We come now to debt restructuring. I have to caution, this is a very complex issue. It's when you talk about scheme of arrangement, generally it will not really apply for the small companies because it really applies for the bigger ones. This is a very complex issue that will require advice not only from lawyers, you also need financial advisors, because then they will have to advise on whether restructuring is possible, and if so, how to go about doing it. Because you can have either restructuring, or if the company really cannot make it, then it has to be wound up. Okay. All that I want to really just touch on is to give you an idea of what is a scheme of arrangement. Companies with a lot of debts, but they need time to pay. They think that they have a good business that can be safe. What they can consider is they can enter into this thing called a scheme of arrangement, whereby they will get someone to come in, a white knight, and then they will apply for the debts to be restructured. So it will be done in such a way, just as a very rough example. Someone, a creditor who is owed $1, at the end of the restructuring, the creditor may get back 30 cents or 50 cents to the dollar. So all the creditors will take a haircut. Okay. An example of a attempted restructuring that I think everyone knows about is that of High Flux. That's been going on for a long time. I think about 1.5 years later, we don't even know what is the detail of the restructuring yet. So this is a very is a very lengthy one. Construction companies between 19 and 20 have also, quite a lot of construction companies have also undergone restructuring. An example would be Kun Holdings Limited and Kun Construction and Transport Private Limited. These two companies, the restructuring was successful. The restructuring has been approved by the court. Okay, so restructuring, how restructuring is done, we have to get firstly support from the creditors to the scheme. If the majority of creditors say no, your scheme is horrible, I don't get any benefit, too bad, the restructuring will not go through. So the company can say that I will pay the debts of the creditor either by cash or by issue of new shares. Okay, and then there will be this thing called a court moratorium. It is basically similar to the relief that is granted to the tenant, because in this case, when you talk about moratorium, it says basically a court protection period whereby no legal action can be started or continued against the company during the period of moratorium. So like you read about the high flux one, after 1.5 years later, there is still a moratorium. Okay. The idea of a scheme of arrangement is that after the scheme, the company will come out much leaner for sure, because all the debts have been restructured, and then hopefully stronger. Okay. That is all I have. Like I said, restructuring is a very complicated subject that is not so easily to be resolved.
So this one have to involve liquidator, right? Lawyer and liquidator.
You have to involve not the liquidator, you have to involve financial advisor.
Okay. Which is liquidator. No. That's restructuring. That's restructuring.
Yeah.
Probably the
restructuring expert. You have got the big four, got BDO, all this stuff. The accountants.
Okay, sure. Great. You have covered all topics? You have covered all,
yes,
right?
I've covered. This is the end of my slide and my presentation. So if anyone has any questions,
I think you have addressed all their questions along the way.
Okay. Good to hear that.
They probably can have better sleep tonight.
Hopefully.
Yes. So do you want to share with us, like, for example, live cases that you handle, like pertaining to the topics tonight, which you can actually give us the summary for tonight, the topics, because tonight, right, is about pandemics, you see. So it covers tenants and landlord, and it covers creditors and debtors, and it covers what is that? The first one, the employment, the employer and employee, right? So probably you want to give a summary for everyone.
Okay, no problem.
To wrap up for sharing section tonight.
Okay, let me just wrap this thing up very, very quickly. We are actually in a very unique, and I hope this is a once in a lifetime thing, because nobody wants to go through this whole thing again. Everything is still very new. It's still in a state of flux. I think when it comes to the area of landlord and tenancy, have a word with the landlord if you are the tenant, and if you're the landlord, have a word with the tenant. Try to see what can be done. There's no need to like be unreasonable, to try to posture, to try to get your way. If you are not certain, have a look at the Ministry of Law website. It's very easy to search. You just search Ministry of Law, COVID, landlord and tenant. You'll find a lot of information there. If you need to serve any notification for relief, the information is there.
Great.
So we have got everything, a lot of things online for as far as landlord and tenancy is concerned. When it comes, then I backtrack. When it comes to contract, that one not so straightforward unless your contract is one of the 7. If not, you may have to see a lawyer to see what can be done. Either that or discuss with the other party. If you need, for example, you need more time because you can't perform, have a word with the other party. If the other party is unreasonable then I'm afraid, you may have to seek legal advice. Then when it comes to retrenchment, this is something that not everybody wants, whether you're an employer or the employee. I think at the end of the day, some compassion should be given by the employer to the employee. And I think if an employee actually sees that the employer has done its best, I think the employee will know. Okay. In terms of the ongoing cases, I've not done any landlord and tenancy one. I have done a case, a secured claim by acting for a property owner whose bank claim against him for non-payment. So for that, we actually filed the notice for relief by the owner, and then we also applied to stop the court case. So that one is quite straightforward. Not to me, it's not very complicated lah. Again, a lot of information is online. If you want the notification for relief, you can even do that on your own.
Yes, I think
Then hit the
nowadays a
court
lot
pass.
is on the web and can
Correct.
Google about it. It's just
Correct,
that a lot of times, right, because their information, they are so nowadays it's not lacking on information, but more on too many informations. So we might
Correct.
need some guidance like where is
Yeah.
the information. So just now Colin has highlighted that the information can be found at the Ministry of Law under landlord or tenant. So you can actually Google also if you need the notice of relief or you need to have the assessor form or something, right?
Yes, everything is online. I've not personally gone to see it, but like the notification for relief, I know it's there, just that I've not actually seen the form.
Sure. That is good enough already to point us to the correct website. We really thanks for your times, your precious time. I know you are very, very, very busy. And for the section tonight, right, we has been queued for 2 months for Colin to come and talk to us about this matter. In fact, when the COVID just started, which is about May or June, we already started to invite Colin to come aboard to actually share about these topics. But he has been ongoing having court orders, court cases to actually handle litigation and he is very, very busy. So for him to come on board tonight, right, is a really, really precious time for us. And all the preparation work, all the time spent, and then all the sharings tonight is invaluable to every one of us. We have a big thanks to Colin. Thank you, Colin, for your time.
Thank you.
And on behalf of all the participants, I hope that everyone can have a bit more prepared or can understand a bit better as in your rights, your legal rights, and the changes in law that you cannot enforce your legal rights as you before already. So you can actually go back to our Facebook page to like our page, to follow us, so that subsequently, right, you will be notified and you can actually go to look at the video again and to go through the whole things again and follow us so that whatever upcoming courses and event, you'll be notified promptly. So once again, we thank you, Colin, for the times. Thank you, Colin.
Thank you.
And thank you, everyone, for participants tonight. All the participants tonight. Thank you so much.
Thanks.